Peace, fam. Ah, 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 ah. So, we are going to continue reading through Citizenship and Expatriation. So, with all that being said, let's begin reading. Live streaming. So let's do this. Now, we're going to continue off from page 45. Alright, so we are right here. Page 45. And, mind you, these are all Supreme Court case laws in reference to citizenship and expatriation. So let's keep on going. Jansen, 1795, 3 Dahl, 133, and C. Gacy's versus Ballin, 1832, 6 Peter, 759. The principal has received a rather careful statement in the case of United States versus Cruikshank, 1785, 92 U.S., 542, 550. The people of the United States resident within any state are subject to two governments, one state and the other national, but there need be no conflict between the two. The powers which one possesses the other does not. They are established for different purposes and have separate jurisdictions. Together they make one whole, this being public and the private. You understand what I'm saying? You have your national and your state, public and private. Alright? What they would say, church and state. See what I'm saying? The church is the national side. The church itself, the church is fellowship. The state is the civic side, getting things done, building, creating, building opportunity for one another. All right. So let's continue off from right here. They are established for different purposes and have separate jurisdictions. Together they make one whole and furnish the people of the United States with a complete government, ample for the protection of all their rights at home and abroad. True, it may sometimes happen that a person is amenable to both jurisdictions for one and the same act. This does not, however, necessarily imply that the two governments possess powers in common or bring them in conflict with each other. It is the natural consequence of a citizenship which owes allegiance to two sovereignties and claims protection from both. The citizen cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres must pay the penalties with each exact from disobedience to its laws. In return, he can demand protection from each within its own jurisdiction. So pretty much that statement is that if you're willing to submit yourself, aka contract, with foreigners and submit to their jurisdiction, you have no rights to complain. Meaning all those people who go and do protests and stuff like that, you have no rights to complain. I was having a conversation with a sister yesterday, and she was pretty much asking me, the question she asked me was, how does she know that the treaties will be honored, right? That was her question. Meaning we were talking about the Treaty of Peace and Friendship. So she was asking me, how does she know the treaties will be honored? You know, especially seeing what the natives are experiencing today. And this is what I responded to her. First off, the natives that are there protesting at the pipeline, the Dakota pipeline, those aren't the true and original natives, right? Or let me rephrase that. They are natives, but they're not indigenous. Example, and I'm not going to go too far. If I'm born in Japan, but my mom and my dad are from America, I could be native to Japan, but that don't necessarily make me Japanese, because my bloodline is American. You see what I'm saying? So just because you're born somewhere doesn't make you necessarily of there, but you can be native. You can be born from there, but that doesn't mean that your bloodline is from there. So that being said, the natives who we're talking about today are not the original peoples of the land. They're not tied to this land. They are actually the manifestation of the Asiatics, or the Asians, who came over here, to do business with us here, and those Asiatics, and they pretty much mated with the Caucasian woman, and pretty much these are how the natives that we have today are formed, but they are not original to Coco Bay, all right, which is the ancient name of this landmass in Japan. Coco Bay means land of the bays. So with that being said, I pretty much laid down to her that, once again, if you submit to the jurisdiction of a government, then you have no rights to complain about it. So what happens now is all these so-called native tribes, they are under the jurisdiction of the United States because they're all a part of the Bureau of Indian Affairs. Okay? Meaning that they're all receiving a stipend from the United States every year, or however they get paid, quarterly or whatever. They're receiving that annually. This is how you have a lot of so-called native friends. People who have native friends. They're always receiving stipends from the government. Pretty much they're sucking off the titty of the U.S. corporate. So what happens when the U.S. corporate no longer decides to give them milk? Alright, so because of that fact, it is irrelevant for them to dispute or argue anything that the United States does, as long as they remain submitted to their jurisdiction. Don't you think it's kind of weird that they're limited to a reservation when we have a great land? You have a whole continent, but you limit yourself to the reservation and then give the foreigners the rest of the land? How does that make sense? It doesn't to me. So this is why the treaties are not honored, because those aren't the actual people that those treaties were made with. And then in reference to that, I told her I've worked a few part-time jobs. I haven't paid taxes for over 2 years now. Exercising the treaty, operating as myself, I haven't had any issues. The treaty has been honored just fine. So, it's just all about perspective and experience. So through my experience, there's nothing wrong with the treaty. And the United States has every right to not honor the treaty with the natives, because you cannot have a treaty with someone who is subject to you. So as long as those so-called native tribes remain subject to the jurisdiction of the United States via the Bureau of Indian Affairs, then they are still slaves of the United States. So it may give off the appearance of sovereignty, but it's not. And we got to be able to see through that falsehood. You know what I'm saying? We are the Aborigines, the original people of this land. So we hold a superior claim in regards to blood and soil. Alright? So let's continue off from here. So let's regain and recapture so we can understand, right? It is the natural consequence of a citizenship which owes allegiance to two sovereignties and claims protection from both. The citizen cannot complain because he has voluntarily submitted himself to such a form of government. He owes allegiance to the two departments, so to speak, and within their respective spheres he must pay the penalties which each exacts from disobedience to its laws. In return, he can demand protection from each within its own jurisdiction. Meaning, within both jurisdictions, you can step in, okay, and you can function, meaning you can function with the full rights and protections of the government, right? So you have to understand, we're natural born, going back from the last video. And if you're catching on now, I would suggest that after this live stream, you look at the first session, the first reading session, so you can kind of start putting, so everything will make sense. All right, because this is a continuation from the first podcast. So, you know, all natural persons or natural born citizens of the United States can only be melanated people, Aboriginal people who actually are from here. And how do you know you're from, how do you know that you're descendant from America? Here, you trace your mother's bloodline. The inheritance comes from a mom. You know why? Because your daddy is what is what his mama is, and if you're a son, you are what your mom is. Because a mom produces a man and a woman. Man and a woman. She produces both. Okay? She produces both. So you follow the bloodline of the woman. Right? You don't follow the Y chromosome, you follow the X chromosome, because the X chromosome has 4 legs. The Y chromosome only has 3. Okay? It means it's missing one. So if you take an X, right? If you take an X and then you clip a leg, then you end up with a Y. Okay? So we're missing a strand of DNA. We're not complete as men. We're incomplete. Alright? We need to understand that. So if you can follow if you can follow as far back as your great grandmother, meaning at least 3 generations, your great grandmother on your mother's side, trace back where she is. Let's say if your grandmother was born in like Alabama, your great grandmother was born in Alabama, then you will know that you descend from the Cherokee people. So you need to look into the original people of Alabama. And then you'll just start seeing names of tribes start popping up. And then I'm pretty sure things in your mind will start coming to mind of like little sentences or little things, you know, grandma or your auntie or a family member said here about, yeah, you know, yeah, we're Cherokee, we're Blackfoot, something, you know, we're Seminole, we're Gullah, you know, something referencing Indian in the family, when in reference we are actually the Indians. All right. So only natural born citizens, only melanated people are natural born citizens. So being that we're natural born citizens, we still have first allegiance to our mother, which is our national citizenship, which is to our national culture and our origin, right? That is the meeting grounds for us as a people holding a culture and a free national name, which is Moorish American, right? That's the free national name that we as a people are coming together underneath, okay, in the various territories that we're domiciling in. So, you know, with that being said, being yourself allows you to be able to operate in both your private capacity and your public capacity. In reference in the public capacity, right, I have a public trust with a so-called ID card from the state, which I like to reference or call a gym membership card or a state public trust card. That's what I like to call it. It's not an ID card. So with that card in my free national title, it entitles me to protections now because I'm coming in the name of my ancestors. Although it is the name of an entity, I have the copyright to that entity because it was created by me, right? So therefore, with that being said, I have copyrights to it. So now, if it's used in any way, shape, or form without my consent, I have rights to remove all liens. You know what I'm saying, and enforce all contracts. But you also have to keep in mind that the contract that protects me from being violated, or that I am now a party of again, is the Constitution. And the reason why I'm a part of the Constitution once again is, for one, I'm coming once again in the name of my ancestors, whom with those contracts were made with, right? That's for one. And number two, I'm not classifying as black or African American anywhere within their system. So meaning, even in reference to a social security number, which, you know, depending on people's situations, like I said, it's up to them if they want to get rid of them. But if you have other ideas on what to do with those bonds, and this is not legal advice that I'm giving, by the way, I'm just throwing out ideas. You know, you do your own research. But you know, understanding what those bonds are, and then finding a way to put those or assign those within a private trust. You know what I'm saying, under your free national name, so you can do business. But the main thing is, even in regards to the social, because mine is still on the record, I have updated everything. I haven't gotten rid of it. And, you know, in reference to that, I've updated everything to reflect on my status that I am American Indian and white. And not that I am American Indian and white, that my entity, my public trust entity, that is in all caps, still looks like my free national name, is classified as American Indian and white. Why did I do that? Well, for one, because white is not based on complexion, it's based on status. So is American Indian, it's based on status, not really a complexion. We're talking about an entity here, not you as a human being. So now that entity has origins in people, right? Because black and Africans do not have origins in people. So if you don't have any origins in people, or I should say, if the entity you're using to conduct business with the United States, all right, does not have any origins in people, that means that it is a stateless entity, meaning it's abandoned. There's no captain. It's a ship without a captain. So if it's a ship without a captain, it's like, that's a nice ship too. It's a really, really nice ship. And if it's a nice ship and there's no captain, then it's for whoever finds it, right? So this is what's happening now. So being that I'm captain of the ship, I have full protections whether I'm in the public and also when I'm in the private, both commercially and civilly. All right. So let's continue. As suggested above, the courts have always recognized the distinction between the two citizenships. In Talbot versus Jensen, Supra, it appeared that provision had been made by a state constitution for renunciation of allegiance to the state, while recognizing the efficacy of this so far as it concerned the state. The Supreme Court held that it had no effect as to the party's allegiance to the United States. Therefore, a state citizenship may be lost by renunciation, or as it appears from Prentice versus Brennan 2 Blatch 162, by a residence outside the state without any way affecting the national citizenship. Moreover, it has been held that one who during the late rebellion espoused the cause of the South and maintained his allegiance to the state did not and could not by this act renounce his citizenship of the United States. While some courts have indeed scouted the idea that there can be a citizen of a state unless he be also a citizen of the United States. Meaning there's no way to be that a person can be a citizen of a state if they're not a citizen of the United States, because the United States, and I'm not talking about the company, I'm talking about the United States First Continental Congress generally assemble. Alright? So, in reference to the First Continental Congress, we're talking about the continent, North America continent, the water and the land. Alright, so if you're not a party or a citizen of the United States, if you're not a citizen of the land, known as America, then there's no way in the world you could be a member of any state, period. Whether that's a tribe or whatever. Alright? Now, let's keep reading here. And let's continue from here. While some courts have indeed scouted the idea that there can be a citizen of a state unless he be also a citizen of the United States, and hence that to become a citizen of a state he must comply with the national naturalization laws, this result has not always been reached. However, for in the case of N. Ray Wehlitz, 1863, 16 WIS 443, where the facts before the court were familiar to that in the case last cited, the court held that one might be a citizen of a state, although not a citizen of the United States, and hence to become a citizen of a state, it was not necessary that the national naturalization law should have been complied with. This later seems to be the general view. Alright? And this is the case law right here. The question of state citizenship as distinct from national citizenship is most frequently raised in connection with two classes of cases. First, those in which it is sought to compel state authorities to permit an applicant to vote on the theory that suffrage is the inalienable right of a citizen. And secondly, those in which the question to be determined is whether or not a party is a citizen of the United States or of a state within the clauses of the Constitution relating to jurisdiction of the federal courts. Bang, bang. First, the right of suffrage. While some courts have insisted that such was one of the distinguishing marks of citizenship, if not of national citizenship, then of citizenship of the state. Let's look up what suffrage. Let's look up what suffrage. 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 A vote, the act of voting, the right or privilege of casting a vote at public elections. The last is the meaning of the term in such phrases as the extension of the suffrage, universal suffrage, universal voting. Alright, so suffrage means vote. So the right of voting, right? Essentially, the right of voting. Now, see in Ray Wiltz, 1863, yet the courts almost unanimously have denied that the two had any necessary connection, and that not only might persons who are not citizens exercise the elective franchise, but that citizens as such were not entitled to vote, not even within the provisions of the 14th Amendment. A number of cases bearing on the subject are collected in a note below. Meaning that as being natural born citizens of the United States in General Congress assemble, right, for the United States the land, not the United States the company. You see what I'm saying? Put like this. It makes no sense for us to vote in a system that doesn't affect us. Why? Because it's not our home base. The United States is considered, like I said, a gym. Just think of it like a gym. If you go to a gym and you sign up for a membership, you get a membership card, right? Anytime you need to use the gym, you just show your membership card. They let you in. Boom, 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 boom. You do what you need to do. You work out and you go back home. The only time you need to use that gym membership card is when you go to the gym. So what happens if, now mind you, this is the only gym in the neighborhood, right? So what happens now if that gym shuts down? That gym is no longer around. What do you do now? Do you stop working out? No, 9 times out of 10, you're going to continue to work out at home because home is your base, okay? Home is your base, meaning there's no need for you to vote whether the gym survives or not. That has nothing to do with you. That's not your jurisdiction. You simply use it when you need it because it's made available to you on your land, so you have access to it. And if it's gone, it's gone because it wasn't there in the beginning anyway. So meaning that once we reclaim our nationalities, we need to bond together like glue into states. And then when we have issues, address them as a state. You understand what I'm saying? And then when it comes to the voting issues, we need to address our opinions on what needs to be done as a state. That's called casting a ballot. All right? Casting a ballot. So, let's keep on keeping on. Second, the question of citizenship as affecting jurisdiction. This point may, for the purpose of this report, be briefly disposed of. In the case of Prentice versus Brennan, already referred to, it appeared that a party had left the United States and had gone to Canada, where he had lived for a number of years. It was held that although he had lost by such residence his state citizenship, within the meaning of the constitutional provision which permits citizens of different states to bring suit in the federal courts, he had not lost his national citizenship. The same result was reached under similar circumstances, except that one party was still resident abroad. Alright, so meaning that he moved to Canada where he lived for a few years. That didn't remove the fact that his national citizenship was of the United States. Okay? And mind you, we're not talking about Aboriginal peoples yet. This is in general, right? This document gets very specific. Because whenever I see this document, people, it seems to me, just go for the Morocco part. Right? They just go straight for the Morocco. Citizenship in Morocco. But what was being said up to that point? This is why I'm reading this from the beginning and working my way up there. The part about Morocco is like page 400 and change. So we at page 47. Alright? We only full understanding. Full understanding. Okay. So we're going to continue from here. The same question has frequently arisen with relation to the citizenship of an inhabitant of the District of Columbia, whether such a one was a citizen of a state within the meaning of the Constitution, and the answer has uniformly been in the negative, though the courts have in most cases at the same time either expressly asserted or assumed that the parties were, notwithstanding this, citizens of the United States. The same result has been reached where the question has arisen in connection with an inhabitant of a territory. Alright? Orleans versus Winter see American INS Co. and in St. Reese, Ohio. The same ruling was declared with reference to residents of government reservations. Second, status of residents. The question must arise as to whether or not one may gain or lose citizenship in the nation by residence in or away from a country. Some phases of this are discussed in connection with questions of expatriation, Part 3, but a few preliminary statements seem desirable. It is entirely clear that one who resides in a country assumes a certain relationship to it, which differs from that assumed toward any other foreign nation, and that on its part the nation in which he resides stands in a relationship toward its alien residents different from that which it has toward non-resident aliens. Alright, so your relation...
Aliens are real?
Yeah, but not the green looking ones they talk about. When they say aliens, they're just talking about someone who's not from somewhere.
I thought you meant the green aliens.
Well, when you think about it, meteorites, those are aliens. Because they come from the stuff. Because they come from the sky. Anything that doesn't come from here is considered alien. So even in a country, if you're born in like Africa and you come over here,
They have meteoroids coming there, asteroids there too. So
yeah, those are aliens.
So if an asteroid hits Africa, everyone's dead, right?
Maybe not.
But the animals might not. Animals are.
I mean, there's gonna be some people who ain't gonna make it, but
How do you survive?
I don't know. I've never been hit by a meteor. Oh yeah.
Funny you
Okay. So, I want to hear about it later, all right? Tell me about it later, okay?
Yeah.
Alrighty. So, let's continue. It is entirely clear that one who resides in the country assumes a certain relationship. So, if you're aboriginal to a specific place you were born, then you should express naturally a certain relationship between you and the land which you are existing on. I mean, that relationship can be expressed within culture, how your national dress attire, you know what I'm saying, how you present yourself, how you speak, you know what I'm saying, your demeanor. All these things are reflections of your relationship to the dirt you are standing on. All right? So, and people can tell who is who. As funny as that sounds, people can tell who is more in tune with the land by the manifestation of how they relate to the land. Thus, headdress, feathers, jewelry, language, you know what I'm saying, rituals, special dances, these different type of things express that there's a relationship, a special type of relationship, unlike the relationship with other people. And like I said, that disconnect can be seen, and that's how aliens are identified between people who are not aliens. All right, so that's what's being made in the statement. You know what I'm saying? So, the relationship existing between a country and an alien resident was explained by Mr. Chief Justice Gray in United States versus Wong Kim Ark, 1897. Such allegiance and protection were mutual, as expressed in the maxim, protectio trahit subjectionem, et subjectio protectionem, and where not restricted to natural born subjects and naturalized subjects, or to those who had taken an oath of allegiance, but were predictable of aliens in amity, so long as they were within the kingdom. Inhabitant of the state, but he was not, in any sense known to the law, an alien. It would be quite preposterous to say that a native-born citizen of the state becomes an alien to its laws by going to reside in another of the states in the Union, or even in a foreign country. The provision of the federal constitution which declares that the citizens of each state shall be entitled to all privileges and immunities of citizens of the several states precludes the objection of alienage from being set up in any state against a person born in any of the United States, and constitutes all such persons, for all legal purposes, citizens of each state in the federal union. They are not. It is true, resident citizens of any state except the one in which they are domiciled, and cannot claim any rights belonging peculiarly to residents out of their own state. But the statutory disability attaches only to such as are both aliens and non-residents. There is no reason to suppose that the term alien was used in this statute in any other than its legal sense. That is, at the same time, its popular meaning, and the word, when used simply and without any qualifying language, cannot have any other signification than the one which the law and common parlance affixes to it. This alleged ground of disqualification cannot therefore be sustained. In the earlier case of Carlisle versus United States, 1872, Mr. Justice Field laid down the controlling principle in these words: "The rights of sovereignty," says Wildman in his Institutes on International Law, "extend to all persons and things not privileged that are within the territory." So once you start talking about sovereignty, you immediately talk about international law. If you're not talking about international law, you are not talking about true sovereignty as a people, not as an individual. Alright? So, they extend to all strangers therein, not only to those who are naturalized and to those who are domiciled therein, having taken up their abode with the intention of permanent residence, but also to those whose residence is transitory. All strangers are under the protection of the sovereign while they are within his territories, and owe a temporary allegiance in return for that protection. By allegiance is meant the obligation of fidelity and obedience which the individual owes to the government under which he lives, or to his sovereign in return for the protection he receives. It may be an absolute and permanent obligation, or it may be a qualified and temporary one. The citizen or subject owes an absolute and permanent allegiance to his government or sovereign, or at least until by some open and distinct act he renounces it and becomes a citizen or subject of another government or another sovereign. The alien, whilst domiciled in the country, owes a local and temporary allegiance which continues during the period of his residence. So this goes into hopping in and out of the matrix, right? So I'm gonna vibe out on something real quick. Thank you very much, those who post information up. I'm looking for the article. You can see here, number 3, rights of citizens to free and lawful speech in public assembly shall not be denied. Access of citizens to the ballot box shall not be obstructed either by civil or military power. Remember, we need to cast a ballot, not a vote. We need to look up what a ballot is. Okay? We need to cast a ballot, not a vote. You only cast ballots as a family. Alright? And it's already enough to understand that we cannot be citizens. You know what I'm saying? We cannot be citizens. However, we can engage and conduct in business using a 14th Amendment person. That's what it was created for. You know what I'm saying? Besides the fact of bringing the South back in, or those who fought against the South, you know, who went against the Union, pretty much in terms of the slavery period. But other than that, everything is being conducted through straws. All right, that's where the 14th Amendment comes into play. So, So, let's just keep going. Okay. These statements, while clear as to the general principle controlling leave, however, unsettle certain other and specific questions. In the first place, the courts have held that the law presumes that all persons who live among us are citizens until the contrary is shown. So it is assumed that we are all the same until it's shown otherwise. Okay? Consequently, where a party was known to be born here, although it is not shown that his father, who was foreign born, was not an alien, and although during the party's infancy his father moved out of the country, still the party was considered a citizen. Alright? The same principle was applied under the Treaty of Peace, in connection with persons who were shown to be domiciled in America before the close of the revolution with a continuous residence afterwards. So now understand, there were tons of Treaty of Peaces, okay? The Treaty of Peace and Friendship is a major one, is because Morocco was the first nation to recognize the United States, right, as a sovereign nation. But you got to remember, the Treaty of Marrakesh, which is the actual original name of that treaty, of 1786, Morocco, or so-called Morocco, the kingdom that we know today, was created in 1956. So how is it that, pretty much put it like this, if the Treaty of Peace and Friendship is older than what we call Morocco today, right? Once again, the Treaty of Peace and Friendship is in 1786. The Morocco we know today was formed in 1956. So if we're talking about the Treaty of Peace and Friendship, and we're talking about the Moors, and there is no Morocco over there yet established, right? Because it's not 1956, it's 1786. Then what Morocco are they referring to? And yet, for somehow, George Washington is writing the Sultan, right, from New York. That treaty wasn't signed in Morocco. Couldn't have been. Morocco wasn't formed then. So obviously this is Morocco when you're talking about the landmass. When you're talking about the landmass, okay? And I'll have other things, other little treats to make that real too. But in connection with persons who were shown to be domiciled in America before the close of the Revolution, with a continuous residence afterwards. All persons who are found within the limits of government, whether their residence be permanent or temporary, are to be deemed so far citizens or subjects thereof, as that the right of jurisdiction, civil or criminal, will attach to such persons. So what are they saying here? Whether your residence is permanent or temporary. How can your residence be temporary? If you exercise what is called dual citizenship, which first is citizen, which is national citizenship, which is citizenship to your state, and then citizenship or temporary citizenship to the United States. All right, that is dual citizenship. So either you're going to be two things, right? Either you're going to be a citizen or you're going to be a subject, meaning you're going to be a member of that company, to where everyone who is a member shares rights and protections by the Constitution, or you're going to be a subject of that, meaning you can be mistreated by the citizens. All right. Moreover, one alleging the alienage of a party must prove it. Another principle has, however, been laid down by the cases that where the original status of a party in an action is shown, this is presumed to continue if there be no evidence of the denaturalization or naturalization. In Hornstein versus Lindman, there is no proof that he denationalized himself or ceased to be a citizen and subject of Switzerland. His original citizenship is therefore to be presumed to have continued. And see also Hogan versus Kurtz. Over the party in the last case swore that he had been naturalized and had lost his papers. The fact of long continued residence should of course make no difference on this question, and it has been so held. 10 years residence, so in regards to this case. The principle has also been applied where a naturalized or native-born American citizen has denaturalized himself and then has returned to the United States. In such case, the courts have held that the party had acquired an alien citizenship and continued to be an alien, although subsequently returning to and residing in this country. Citing and relying on Hornstein versus Linham, Supra, Aylesbury versus Hawkins. Another interesting case in which the doctrine was applied in State versus Salge, 1865, where the defendant called in question the alienage of one of the jurors before whom he was to be tried. It appears that the juror in question was born in the province of Canada and lived there until he was 24 years of age. He had been told that his father was a citizen of the United States prior to removing to Canada, which was before his birth, and that he never had any knowledge that his father became a citizen of Canada. He also stated that he did not know of which country his father claimed citizenship, that his residence and home was in Canada so long as he knew anything about it, and that he, the juror, had never been naturalized as a citizen of the United States. The defendant's challenge of the juror was allowed, whereas in Miller versus Supra, a challenge of allegiance is alleged. This, of course, must be established as any other fact. A number of cases have come up involving the principle stated in Jackson versus Wright, Supra, the fact of long continued residence, among which are three that arose just after the Revolution. In one, the alien, whose citizenship was being considered, had resided in New York as a prisoner of war from September 76 to January 1777. It was urged that this made him a citizen of that Commonwealth, but the court found to the contrary. 2 years after, in the second case, the question came up as to whether or not continuous residence after the Revolution by a soldier of Burgoyne's army made him a citizen, and the court found that it did. And a similar result was reached where the party in question had been a deserter from the British Army. Now, Springfield. It seems that in neither of these cases was the result reached on an interpretation of the treaty. Alright, in People versus Riley, the court of that state declared that residence and service as a soldier were not sufficient to confer citizenship. The courts have consistently held also that residence in a foreign country by a naturalized American has no effect upon such person's citizenship. The question came up under a rather remarkable state of facts in Young versus Peck. It appeared in this case that the party in question was the daughter of one who after her birth became a naturalized American citizen. She was born abroad in Scotland in 1769. She lived abroad until 1830. She married in Scotland probably before she became of age, a British subject with whom she lived until his death. When she came to America, the court held that neither her residence nor her marriage had any effect on her citizenship within the Act of 1802. This was affirmed on appeal to the Court of Errors in 26, Wednesday. For an application of the same principle, see Ware versus Wisner, and a whole slew of other cases. A number of interesting cases have arisen touching the point whether or not one residing in this country before the Revolution became an alien by either fleeing the country on the outbreak of the war or by taking refuge with the British Army. Now, Chief Justice Marshall said, "The settled doctrine of this country is that a person born here who left the country before the Declaration of Independence and never returned here became thereby an alien and incapable of taking land subsequently by descent in this country." Accordingly, it was held that where the defendant, born in the colony of New York in 1760 of Irish parents, went to Ireland to be educated in 1771, was educated and served his apprenticeship there, and returned to the United States in 1795, he was held not to be a citizen. An opposite result was reached. The principle itself was well stated in United States. Gills, 1815. It is true that a man may obtain a foreign domicile which will impress upon him a national character for commercial purposes, and may expose his property found upon the ocean to all the consequences of his new character. In like manner, as if he were in fact a subject of the government under which he resides, but he does not on this account lose his original character or cease to be a subject or citizen of the country where he was born and to which his paternal allegiance is due. His perpetual allegiance is due. Just taking a little bit of a break. Been reading for a little bit. Let's give ourselves a chance to let the information simmer in.
If I was a therapist, I would prescribe this. Oh, you're anxious? 2 fritas every day. I feel so much better.
I am having a blast with a beat, I am ripping it. Old school with some new heat like my timber. And you can find me on the streets of London, entering or in studio, getting it or at the apple tripping, man. Man, they say love goes through the stomach. So now let me hear you say.
We are here in Miami at El Rey.
Stuck here watching myself, just want to make sure everything's working well. Okay, everything looks good. I'm cool with that. Is it? Is it still breaking up? So,
Moved the lamp over there yesterday.
yeah, I moved it.
You don't want the regular light on?
Nah.
I don't like the regular light either.
Bear with me, family. I'm gonna get this rocking.
Kept my light off all day. I didn't even cut it on when I had to put my clothes on. I was like, nope, I ain't about that life anymore. putting my clothes on in the lounge, like.
Alright. Okay, let's continue going. So,
As you were saying.
the principle was somewhat more fully stated in the earlier case of the Venus, 1814, 8 Cranch, 253-280, where Chief Justice Marshall laid down the doctrine as follows. But this national character which a man acquires by residence may be thrown off at pleasure by a return to his native country, or even by turning his back on the country in which he has resided on his way to another. To use the language of Sir W. Scott, it is an adventitious character gained by residence and which ceases by non-residence. It no longer adheres to the party from the moment he puts himself in motion, bona fide to quit. Uh-oh. Let's find out why am I dropping frames.
It always says, disc burn. I'm like, what does that mean? It was like, it's burning? Like on, like black or like real black when it's burned? And that's what always happens to me when I'm on the computer. And I'm watching something that says disc burn. Disc is burning. I was like, weird. Don't wait until Friday so I can go to my dad's.
Nice. Okay. So I'm hoping you guys are bearing with me through this funny stuff happening. But let's continue. Alright, the reasonableness of this rule can hardly be disputed. Having once acquired a national character by residence in a foreign country, he ought to be bound by all the consequences of it until he has thrown it off, either by an actual return to his native country, or to that where he was naturalized, or by commencing his removal bona fide and without an intention of returning. If anything short of actual removal be admitted to work a change in the national character acquired by residence, it seems perfectly reasonable that the evidence of a bona fide intention to remove should be such as to leave no doubt of its sincerity. Mere declarations of such an intention ought never to be relied upon when contradicted, or at least rendered doubtful by a continuance of that residence which impressed the character. They may have been made to deceive, or if sincerely made, they may never be executed. Even the party himself ought not to be bound by them, because he may afterwards find reason to change his determination, and ought to be permitted to do so. But when he accompanies those declarations by acts which he speak a language not to be mistaken and can hardly fail to be consummated by actual removal, the strongest evidence is afforded which the natural of such a case can furnish. So pretty much what they're saying is that if you're truly, you can let go of a temporary citizenship at the drop of a hat if you go back to your native ways, if you go back to your cultural ways. But if you put a declaration stating that you're going back to a culture, or you're going back to a way of life, but your actions still show that you are still actually living the life of a slave, then it makes that null and void. That's what that's saying right now. Okay? But the court seem universally to have drawn a clear distinction between citizenship and this sort of domicile. As to the character of the domicile with a merchant acquires who resides and trades in a foreign country. Of course, if in addition to acquiring this domicile, the party also takes an oath of allegiance to the sovereign of the country in which he resides, he is, while residing in that country, a subject of the same, and is not entitled to the protection of his first government, and is entitled to the commercial privileges of his second. As will be pointed out more fully later, the foreign domicile of an American citizen has no effect upon the citizenship, not only of himself but of his children, and that even though they may be children by an alien mother. The domiciliary status received a number of important adjudications in connection with our Chinese Exclusion Acts. It seems to have been well settled under the earlier statutes that a Chinaman who had acquired a domicile in this country and then went to his native country on a temporary visit stood on his seeking entry into this country on a different basis from when entering for the first time. But the more stringent statutes passed since that time have been interpreted to mean that this right may be withdrawn by Congress. That a party entering this country after having acquired a previous domicile stood on a different footing from a new immigrant was also decided in the case of In re Pangera. Cases have also held that the domicile of the origin is not lost with long residence abroad, even where there is doubt that the party had any fixed intention of returning. Pretty much stating that no matter how long you are lost at sea, you can always come back and claim your abandoned estate. That's what that's saying. Now, inhabitants, not aliens, right? Citizenship by birth. Citizenship by birth. This is going to be a good one. I'm going to leave this video for a break, and then, oh, why did I open that? That's not good. For a break, and then, and what we will do is we will continue the session either later on today or at some point tonight. All right, and we'll continue this session.